Any mention?
Lordship, I beg to mention item number 28, Lordship.
8.
I'm
Yes.
paying for 1 week time, Lordship.
Who's the other side?
I'm there, Your Lordship.
No objection?
No.
We did respect for the Land Council for the petitioner. This matter after 2
1
weeks.
week, Lordship. 1 week, Lordship.
After 1 week.
Obliged.
Obliged.
May it please your lordship, I beg
Yes.
to mention item number 24, your lordship. Kindly the matter be taken up after 2 weeks, your lordship.
Who's the other side? 24.
Yes, we have already informed that. 24.
Yes, Lordship. For the state Lordship.
This is private respondent also. There is a private respondent also in item 24.
Yes, your lordship.
Who is
Respondent number 3.
you are appearing?
Yes, your
Have
lordship.
any
They are
objection?
for respondent number 3, your lordship. Mr. Kishore is for respondent number 3.
She is there today.
Yes. Yes, yes.
No objection, your lordship.
Yes. Yes. This also same order. Same order. Yes. This will be after 2 weeks.
Yes, your
After
lordship.
2 weeks. Yes.
Master.
Highly obliged, your lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 17, Your Lordship.
No objection, your lordship.
Okay, this matter can be taken up after 2 weeks, Your Lordship.
No objection. Same. Same order. Yes.
Deeply obliged.
May I please, lordship, I beg to mention item number 22 of the hearing is. This matter, I pray that the matter will come out after 3 weeks, lordship.
No objection, your lordship.
This is quashing POXO
Quashing POXO matter, lordship.
matter. Issue is pending in the DB.
Yes, your
Yes,
lordship.
lordship.
In the Supreme Court, your lordship, not the DB. We're awaiting a judgment.
Supreme Court, there is a judgment recently
is of
in
another
the
bench.
Bengal case.
Lordship, I pray that this matter may be come up after 2 weeks, Lordship.
No objection, your lordship.
You are for the respondent.
And for the state respondents, your lordship,
Then-
MECL is also here.
Who is for the MECL? They are the main
Lordship, I
respondent.
have
Isn't it?
Lordship.
informed
You have informed already.
yes,
When do you want it?
after 2 weeks, Lordship.
This also is the same thing after 2 weeks as the request.
Obliged, your lordship.
Lordship, similar prayers for item 25, Your Lordship. 25. This also I have already informed the respondent number 2, Your Lordship.
Who is appearing for the state here?
For the state, it's Mr. Karami.
Yes, Mr. Kami, item 25.
Yeah, no objection.
Yes.
Highly obliged.
2 weeks, isn't it? 2 weeks.
2 weeks, Your Lordship.
May please, Lordship. Lordship, I
Yes.
beg to mention item number 19. I pray for 2 weeks' time, Your Lordship.
Yes, you said there was some settlement or compromise. in
Your
the
Lordship,
matter.
with regards to that, I haven't received instruction, Your Lordship.
It is pending for compromise for how long now?
More than a month.
If you are serious to have some kind of amicable settlement, then you should proceed with it. Why should we keep it? Any information?
Your lordship, we've received instructions, your lordship. Initially, there was a settlement process, your lordship, which the government has agreed that he'll be paying on installment basis. And for a few months, he's been paying that, but he defaulted again. Your lordship, this instruction, I may
Was
be
there
allowed.
any formal agreement entered into
Your lordship, if
laying down the terms of settlement? No.
if I could place these records
Please,
on the next
please
date, your
procure,
lordship.
since they're asking for time,
Yes, your lordship.
we'll grant it, and in the meanwhile, you just
Yes, your
obtain
lordship.
latest.
Yes, your lordship.
Yes, also. MS Sir, Learning Council for the petitioner. Please for grant of some time. Stop. MSI Linga, Learned G. Appearing for the respondent has no objection. Prayer allowed. List after
2 weeks, Your
2
Lordship.
weeks. Make sure you do something. You see, what is the purpose? You see, you pass only adjournment order. You see the order sheet. These are full of adjournment orders. Yes.
Obliged.
Obliged, Lordship.
Yes, Your Lordship. So I beg to make mention for item 13, Your Lordship. We already informed Your Lordship the other side, Your Lordship. This matter.
If you inform the other side, that means adjournment will be granted.
Lordship, this is no objection. We have
Who is the other side?
Union, Your Lordship.
2014 matter.
Your Lordship.
Nobody, Dr. Mojika.
Yes, Your Lordship.
No one is there on behalf of Dr. Mojika here.
No, Your Lordship. They are unlike Senator Court.
When do you want it?
2 weeks, Your Lordship.
So just as requested by the Learned Counsel of the petition. This is matter for 2 weeks.
Similar brief item 18, Lordship.
Item 18, who is the other side?
Stated, Lordship.
You are there.
No objection, Your Lordship.
What is the matter about?
This quashing the proceeding, Your Lordship. Quashing of the proceeding.
Quashing of what proceeding?
Uh,
Proceeding under what section of law?
the NDPS, Your Lordship.
NDPS. Your Lordship. No objection.
No objection, Your Lordship.
When do you want it?
After 2 weeks, Your Lordship.
Same order. Yes.
21 as well, Lordship. Item 21.
21 also.
Lordship.
And who is there in 21? Yes.
No objection.
This also after?
2 weeks, Lordship.
Same order. Yes.
Duly obliged.
Oblige, Your Lordship.
Your Lordship, I wish to mention item number 25. Conducting counsel is indisposed, Your Lordship. So I'm here for respondent.
Who is conducting counsel? Oh, this 25 has already been.
Okay.
Verify. Please verify before you mention. Yes.
May it please Your Lordship, I beg to mention item number 26. Let this matter come up after 2 weeks, Your Lordship.
I'm for the respondent.
You are making a mention on behalf of the petitioner.
Lordship, I pray that this matter may be listed for hearing, Lordship.
What is this matter?
For the investigation of the case and file the charge sheet against the accused person.
Objection has been filed
Yes, Lordship.
on behalf of the respondent. You have filed the objection. The Learned Counsel appearing for the parties submit that the matter is ready for hearing. Stop. Let's wait for this is matter for hearing after
2 weeks, Lordship.
2 weeks. 2 weeks.
Obliged, Lordship.
Yes.
Item number 2.
The Mr. Khalindo paragraph you want to
May it please the Lordship.
Yes.
Lordship, items 3 to 12. On the last occasion, my Lord, we had filed a rejoinder against the affidavit of the state government. Lordship, we seek some time to file a rejoinder against affidavit of private respondent, my Lord, about 2 weeks, my Lord.
Okay, you need some more time.
Yes, my Lord, 2 weeks.
Lordship, yes.
Which and is London Council attend for the petitioner praise for and granted. Praise for and is granted further 2 weeks time for filing a rejoinder against the affidavit of opposition of
the private respondent.
Private respondent number or private respondents?
Private obliged.
Obliged.
3 to 12. 3 to 12, my Lord.
Yes, 3 to 12, same order.
Obliged.
Hearing item number 14.
State also is not there. Yes.
Your Lordship, in this matter, on the last date, the counsel for the petitioner, they've withdrawn themselves, Your Lordship.
Yes, it is The order says nobody appeared. So if they're not interested, we'll dismiss it. None appears for the petitioner when the matter is called out. Stop. MS I Lingua, learned GA is present on behalf of the state respondent. Stop. The case record reveals that on the last occasion, also there was no appearance on behalf of the petitioner. Stop. It appears that the petitioner has lost interest to pursue the matter. Stop. Accordingly, the matter stands dismissed for default. Matter stands dismissed for default.
Yes. Obliged, Lordship.
Item number 15.
Yes, Mr. Jha. What is the battle about?
This is, my lord, discharge on the medical ground on the ground of ADS.
Because of your drinking habit.
ADS.
Yes. You are continuing on the
service
basis of the interim order passage.
My lord. And my lord, Army has a every year EME medical examination. Though the respondent authorities has filed an affidavit, my lord.
The rule mandates that an official should be
physically
medically examined every year.
Every year. Every year.
Now, if that is there,
my lord,
which way it helps you?
My lord, it helps that, my lord, I am fit in service, my lord. In spite of serving, even though stay order is there, my lord. The stand of the respondent is that I have been given a shelter appointment. That shelter appointment also.
Now, this interim order was passed in the year 2018.
My lord.
And now you are now continuing it more than 5 years or maybe around 6 years.
My lord.
Now, in these 6 years, every year,
EME.
you were, yes, it was there. Now, what those reports say?
My lord, I don't have.
Do you have details of those reports? Don't you think it will be relevant if we are to basically give some, you see, advantage to you on the
basis of
you are continuing on the basis of it? Or it's up to you.
My lord, that's why I have stated, my lord, every year EME is done, my lord.
Yes, that is okay. But then, what is the report of those?
My lord,
any idea? No.
No,
you do not have any instruction in this regard. Anyway, just give us the facts in a nutshell. Let us see. But then those reports of these recent years, don't you think it will be relevant? Because your discharge is on medical ground. Now, medical ground is one thing which may not remain stagnant. You see, like may not be permanent. It may vary. Today you are not in good health. Tomorrow you may be.
Tomorrow I may be.
So, don't you think that this consideration of those, medical reports of the recent years should be relevant for this?
It is. That's why
we do not know. We are asking you a question. That is for you to.
It will be, my lord. It will be the ground on which I have been.
You are not drinking now. You've given up.
I think.
My lord, what I would pray, my lord, because the cause of action, when it arose, my lord, at that point of time, that he was found alcohol dependence, and that also a case of relapse, my lord. Relapse, what happens, my lord, is somebody is alcoholic and then is given medical treatment, and then he stops it or reduces drinking, my lord, but then again it starts. That is a relapse is a very serious medical condition, my lord. And the reason was because they are armed people, my lord. They carry arms.
Now, the relapse also has to be a frequent relapse, isn't it?
No, my
There
lord.
cannot be a relapse after 10 years or
No,
5 years.
No, my lord. That time, when the cause of action, when we took action against him, my lord, it was a case of relapse. And that was the reason we had to take action against him. Now, he approached this honorable court, stay was granted. He is in sheltered appointment. Sheltered appointment, my lord, they are unarmed now. They are put in peon's duty or some in hospital duty somewhere.
See, this after this stay order was passed by this court,
My lord.
how many times it relapsed again?
We have not done any medical test after that, my lord.
Why?
We have not carried out any
Was
medical
there,
test.
if it is mandated by the law, then why not? See, it was a simple stay order. Stay order makes your
Discharge order.
discharge order inoperational.
So
there was
the consequence was that, my lord, we have to retain him in service. So for retaining him in service, we could not have sent him into regular duty, my lord, because they are soldiers.
No, you have not conducted any medical, the general thing which should have been conducted for 6 years. This is a writ court. You cannot just say that we will confine to the cause of action.
So, my lord, what I pray, my lord, since much of water has flown already, if the matter is disposed of either way, my lord, and Lordship gives us an opportunity, my lord, after reinstating him, because he is already in service.
See, to conduct annual medical examination, this is a mandate of law. There is a right conferred on you. We do not have to.
It appears that because there was a stay order, my lord. Since there was a stay order, he is continuing on the basis of stay order, my lord. We did not do that.
My lord, that will be even ACR. If there is a stay, my lord.
Was there any stay for conducting medical?
No, my lord.
In fact, we even filed a supplementary affidavit, my lord. There we have stated that the Lordship kindly sees para 6, my lord. The affidavit filed on 5th of December 2023.
You have filed a supplementary
affidavit.
Bringing on record subsequent developments.
You filed it on which date? 23/7.
No, my lord.
5th December.
December 23.
5th December 2023.
This is very short.
There is a reply to that.
Para 5 and 6, my lord.
Yes.
Para 5, that the report states that in view of the stay order granted by the Honorable Court, the petitioner was allowed to continue his service with 2 Assam rifles. However, retention of the petitioner in the unit is
2 Assam rifles, there is
2nd battalion. In security threat to the men and material due to his mental instability. Hence, he was not detailed for the general duty for he was enrolled in Assam Rifles and rather has been given sheltered appointment. That the deponent further states that during the period after the stay was granted by this Honorable Court and while the petitioner is in sheltered appointment, the petitioner was granted leave on compassionate ground. However, after expiry of leave, the petitioner failed to rejoin on duty and later voluntarily rejoined on duty after absence of 76 days and he was awarded 14 days pay fine on 20th December 21 under section 26B of the SUNSU. Pursuant to the stay order granted by the Honorable Court, the petitioner has been given sheltered appointment and fresh medical has not been carried out for the petitioner.
The medical board is a different thing. But what about medical checkup?
Medical examination, madam.
That is what. Medical board and medical categorization is a different thing. Where is the regular checkup? See, that is not an exemption. That is a default on your part. You retain him in service, we'll quash this order, and then you'll have that liberty if he is found.
And then will be better. Otherwise, on the strength of stay is continuing for almost 6 years. If Lordship dispose of the matter, at least.
Why you have not conducted regular medical checkup?
Regular because this is the first time he's raising, my lord. This issue. This was never raised.
It is a rule
carried out, my lord. I don't know.
The duty has to be conducted, or what it has to do with his raising that plea or not. If law mandates something to be done, should be done. Even for a normal person. Just supposing you are a fit man, you are there. If law mandates that there should be an annual checkup, that has to be done. The constitution of medical board and the medical categorization is a subsequent issue. When they find that your things are not normal. Otherwise, if you are normal checkup, then why not?
But what I'll pray, my
This would
lords,
have been
dispose of the
better-
matter, my lord.
This would have been better. You see, like you should have revoked that order and allow him to remain in service, and then that liberty will always be there with you. If you find him that the things have relapsed, you can take action accordingly.
In my humble submission, my lord, the cause of action when it arose, and he challenged that medical proceedings on various technical grounds.
My lord,
If he succeeds on that, he'll succeed, my lord.
See, the genuinity of reaction is depend upon the subsequent act.
But in my humble
It is
submission,
not that you just cannot tell us that we should remain confined only till the date of action, and we should not take into consideration the facts which took place after the date of cause of action.
My lord, on the
I don't
earlier,
think that is very attractive argument.
my lord,
on the earlier,
Because it is held, ground is held. Had it
Madam,
been any other allegation
I
that's
kindly appreciate, my lord, only because stay order is granted and matter is pending for 6 years. If the matter was decided at that point of time, this subsequent development would not have been available to him, my lord.
subsequent development goes to his advantage.
It goes to
You
his
cannot
advantage.
deny him. Your very contention that he is unfit to be retained in
My lord.
service gets contradicted by your own action.
No, my lord. That is where, my lord, he is in sheltered appointment. He is not in regular appointment, my
If somebody is unfit to be retained,
my lord.
which he can be in sheltered appointment also, and at the top of the thing, you have not conducted this regular checkup also.
Regular checkup, I am not in a position to
Whom
say,
do
my
you
lord.
allow sheltered appointment? Sheltered this thing, posting. Whom do you allow?
Others, soldiers who are not physically fit, my lord.
But then who are capable to be retained? If somebody is not worth to be retained, he will not be in sheltered appointment also.
But in my humble submission, that again, some difference will come because he's on the strength of a court order.
You see,
He's
the
on the strength
total
of stay out of
ability
part of court, my lord.
and total disablement,
My lord.
there is something in between. A person may not be medically very fit, but then he may be in a condition where he can be retained, like you have said, sheltered appointment. Do you want to say that that position is there only for the purpose of accommodating this kind of cases?
No, my lord, sheltered appointment, what is the concept, my lord? There are some diseases where the process of recovery may take 1 or 2 years. So for that period, we cannot send him to soldier duty, my lord. So we give them temporary appointment for 1, 2, 3 years, whatever.
So that is what you see. The person who is rendered unfit will never be in sheltered. He will not be able to continue there. How is continuing there also, you just say.
my lord,
He's a regular soldier, my lord. He is recruited for the purpose of soldier duty. If he is unfit, he is categorized as P5, my lord. Once somebody is categorized P5, he is continuing only on the strength of stay order, my lord.
See,
Otherwise, there was no reason for us.
Say supposing what happened, if he is a regular soldier,
My lord.
he is rendered incapable of certain medical.
If he declared P5, my lord, he is out, my lord.
If he is not P5,
If he is
is
P3, my lord, we will keep him, my lord, in shelter appointment.
that is what.
But he is not
That is-
P3.
that
my
is
lord.
what-
He is not P3, my lord.
We understand he was not P3 as you say,
My lord.
but then subsequently he has continued. If you say he is P5, he cannot be retained.
Cannot be retained.
Even the court stay order will not make him, you see, like fit to perform his duty in whatever position he is. Do you want to say that sheltered appointments, like he doesn't have to perform any duty? It's a kind of coming to office and sitting in the office.
Possible, my lord. It is very possible.
Don't say it's possible. You see, what do you mean by possible? That means like they do not perform any job.
It's possible, my lord. They are retained only
Nothing,
for
no, my lord.
they are only retained for the purpose that they get well.
What job you are discharging now?
my lord, about general duty, my lord. I have in the
Yeah, so
reply.
instead of performing soldier duty, he is performing office duty, maybe duty of clerical nature. You cannot say that he is not. You see, like there cannot be any post where you would allow somebody to continue 6 years without performing any. It's not at all acceptable.
My lord, we decide to give us liberty, my lord.
My lord, prior to that,
to conduct fresh medical categorization, whether he is fit to be retained for the purpose which he was appointed, my lord. My lord, that liberty should be.
See,
given
that
to
is it? See, a person When he joins in a fit condition, he may be recruited for certain purpose. Now, during course of rendering service, his medical condition may deteriorate, but then not to the extent where he becomes unfit to be retained in service. Then what do? Definitely, you change his position. See, we are dealing with a person where you have rendered somebody, you have ousted somebody from service, saying that he is not fit to be retained in service. But then your act doesn't say so.
No, my lord. My lord, as I submitted for P3 temporary, P2 temporary, my lord, there is a concept of sheltered appointment for giving them chance to recover from the disease, my lord. But this is a case of alcohol, my lord. This is not a normal disease.
You have categorized in P5.
He has been categorized.
Now,
P5,
if he is P5, how could he continue there for 6 years and without any sort of?
Because of the court of, because of the stay order granted.
But then, what prevented you from getting the stay order vacated? Was there any effort by you? No, it means you are satisfied to retain him.
But it should be interpreted positively in our favor, my
lord.
Because we are complying with the court's order.
You are standing up here to argue the case for one side.
My lord, prior to this instant petition, writ petition, my lord, page 108 of the writ petition.
108.
In 2017 also.
Just 108.
108, in Extra 9, my lord.
Yes.
My lord. An affidavit to bring on record the order dated 25/1/2018, my lord.
Yes.
My lord, para 3, page 109, para 3, my lord.
Yes.
That in view of the fact the impugned order under challenge before this honorable court has been cancelled, my lord, by the respondent, and the grievances of the petitioner has been addressed reluctantly. Nothing survives in the instant petition.
That is with regard to a previous round of
previous writ petition on the same ground, my lord. That ADS.
No, but then that was cancellation was by them only.
By them only.
Here they have not cancelled it.
He's a chronic alcoholic, man. That goes against him.
No, my lord.
Even in that year, he was discharged on the same alcohol ground.
If that be so, why you have cancelled it, my lord? You could have contested the matter.
Certain litigations become quite unnecessary, you know. For no reason these litigations are for. Do not know. This kind of actions where earlier also you have taken this action, then he files a case, then you cancel it. And you say that his grievance has been looked into. And then
but the
take him back into service.
But the next document we kindly see, madam. It page 111.
Yes. Page
111.
111. The annexure with that affidavit.
Yes.
Discharge release from service on medical ground, reference headquarters so and so, letter number so and so, so and so. Discharge release from service on medical ground in respect of so and so Saiju PV approved with effect from 1st January 18 by this directorate order number so and so 8 September is hereby cancelled.
Yes.
Request take action as per letter under reference and conduct a fresh IMB proceedings for info necessary.
Yes.
So fresh IMB was conducted by law. Again,
audio was cancelled. Audio was cancelled. Definitely, you found that it is not correct. That's why you have cancelled.
There was only some technical procedural. That is
whatever it is. Whatever it is. Now come to your averment, which Mr. Jha has pointed out just now.
Para 3, my lord. Page 109.
See, it says the grievance of petitioner having been addressed. Now this is a statement made no.
Well, the grievance was only with regard to technical procedural part. But even in the present writ petition, Your Lordship kindly sees the averment, my lord. There is nothing on merit, my lord. He is not saying that he never drank, he is not alcoholic, my lord. He's only challenging on the ground that composition of board was not proper, he was not given proper
That resulted
opportunity.
in that has resulted. The non-adherence to those provisions.
So, my lord, that was on that ground, my lord, the earlier order was recalled. It was not that there is no exoneration that he is not alcoholic and it is total. Only on technical ground. And even in the present writ petition, the challenge is only on technical ground.
You will come with the assertion that he is alcoholic. Well, he will say he is not alcoholic. Yes. So this court basically will not be in a position.
But he is not even saying even in the present writ petition or in the previous writ petition, my lord, he is not saying.
Basically, we are concerned with whether the principle of natural justice is followed or not, and the procedural aspect. That is the scope of judicial review. We cannot go into the merit of your allegation. Okay. Now, if you see your action, first you take action against him. Okay. He comes, raises some technical plea, challenges your action. On that basis, you withdraw that order, cancel it, you take him back himself. Then again you take
with the direction to conduct fresh medical board, my lord. Fresh medical board has been conducted, again he has been found, my lord.
Accepted. Correct. Then on that basis you again take action against him. He again comes back to court, obtains an intervention. And then after the intervention, you remain silent. And you are happy to continue with him. Your very allegation that he is a habitual alcoholic, what happens? It gets washed away because the interim order is passed. Dr. Mojiga, this court is basically interacting. Just see your conduct also is not very appreciable. And that gives advantage.
Our fault at the most, Your Lordship can impute, my lord, is that we did not file an application for vacating this.
Even in this case also, you could have done the same thing if you feel that yes, there are some technical loopholes. We could have immediately, you see, we cancelled your thing. You could have taken liberty from this court to make fresh proceeding to proceed.
My lord, in our case is that there is no technical loophole in the present medical board proceedings, my lord. He came only on that ground. But somehow
even in spite of that, you allowed that this interim order to continue for 6 years.
My lord,
doesn't go.
My lord, kindly see since when the matter is fixed for hearing, my lord. If Your Lordship kindly peruses the order sheet, my lord. Writ petition was filed in 2018, my lord. We filed our affidavit in.
Doesn't matter. You see, there was no effort by you.
My lord.
See, at least the fact remains that you have never sought to.
For last 5 years, the matter is fixed in final hearing.
And then, see, like, then we will be asking you, say, this court will have the liberty, will you give us, furnish us his medical report for all these years. You furnish it, place it before us, we'll take a call on that. We'll assess the correctness of your order.
Well, what I pray, let the matter be disposed of either way, Lordship decide. At least, because he cannot
what is either way?
What is
happening? We cannot pass any order either way. It has
what
to
is
be
happening, my lord,
either this way or that way.
On the strength of stay order, my lord, somebody continues for 6 years, my lord. And maybe he'll continue another for 2-3 years like this, my lord.
Because medical ground. See, once you say somebody is incapable of performing his duty, incapable to be retained in service, that means what? And you see, that means that he person cannot be retained even for 1 day also.
My lord, kindly appreciate, my lord, these are armed people, my lord. They carry guns, my lord. And they are P5 alcohol case, my lord.
Dr. Mojiga, you are going again the same thing. We understand. If you had categorized him as medical P3 or P4,
thing would have been different.
Yes, thing definitely would have been different. Here you say P5. P5 means what? He cannot be retained. Forget about the position of a soldier. Even you cannot retain him in a clerical job, in the official job.
My lord, there is no concept that a clerical person can be converted into a clerical, my lord. That is only up to P3, my lord. If somebody is P3 who has any possibility, medical board says that he can recover from the disease within 1 year, 2 years, then only there is a question. If a soldier, my lord, he is declared P5, then he has to go, my lord. Normally, there is no provision internally, my lord, departmentally. Because the stay order was granted by this honorable court, my lord, we had no choice. We cannot send him to regular duty, my lord. He has been reinstated by this honorable court, my lord. We cannot send him to.
So see, like your assessment
Well,
of P5, whether it is correct or not, he has to go. Do you want to say that?
my lord, when the
Is it not that you see like that you take genuine action? You see, like if a person is genuinely unfit, you take action on it. It is not that you utilize your power to victimize somebody, is it? It is not.
But
Is it? It is not something
my,
like
my answer can only be, my lord, a case of purely physical disease, my lord. Maybe some injury to his hand or leg, my lord. There can be a definitive finding, my lord, that. But when it is a case of, because this your lordship will find the impugned order. I'll just place it. He's a case of psychiatric SHAP, my lord. He's not a case of P. Physical disability, my lord. It's a case of psychiatric disability.
understood. Well, this court is not at all disputing all these things. The only question comes that how he is detained there in 6 years. Then give us his latest medical report, because now we doubt, because of this subsequent development. Now we doubt about your action. There is a doubt. The doubt comes to the mind of this court. So until unless you satisfy us by producing his latest medical report.
Well, what I pray, your lordship may set aside the impugned order, my lord. If your lordship so desires, my lord. That in view of the subsequent development,
the court doesn't desire it.
My lord, but our only case is, my lord, we should have the liberty, my lord, because on the strength of stay order, he cannot continue.
See, your
for 10 to 15
liberty
years,
would
my lord.
always remain. See, this kind of case, can the court take away your liberty? Because medical condition, we do not know what will happen. Today, if a person is well, there is no guarantee that he will not deteriorate tomorrow. He may not have a drinking habit today, but then from tomorrow he may start.
Because he knows.
So there cannot be. This court cannot. If this court, by passing this order will be wholly illegal. If this court passes that order, debarring yourself from taking any action. Cannot be. We are just concerned with the present action, which is before us, which is under challenge before us. That is what.
My lordship wants to test the present action on the basis of his continuance for 5 or 6 years on the basis of strength.
See, that is a normal assumption. What this court understands, that a person is ousted from service only when he is rendered incapable of incapable to be retained in service. That is what. Now, incapacity is something that he is unable to perform any duty. Now, your case doesn't say so.
No,
And
my
there is
my
no.
lord, there in my humble submission, that may not be the correct proposition, my lord. Incapacity will not mean to perform any duty, my lord. Incapacity, because he is recruited as general duty soldier, my lord, his capacity should be to perform the duty of general duty soldier.
See, incapacity to perform means the duties which are there in the department.
His duty,
Okay.
my lord. In the department, there
So
may be 10
you
duties.
want to
my
say,
lord.
if you want to say
Well.
that if a soldier, if he is incapacitated by certain accident or whatever, he is not in a position to perform the duty of a soldier, he will be ousted from service.
Yes, my lord. He'll get his pension, his extraordinary pension, he'll get everything. my lord.
So he will not be retained anywhere else.
He'll not
If
be retained.
he is found to be,
My lord.
you see, like suitable for serving in the official rank.
My lord.
This is the law. This is the law.
This is what is followed, my lord.
Just Mr. Jha,
Extraordinary, because extraordinary pension rules, the many matters are pending, my lord. If in the course of duty he suffers any kind of injury,
no, that
injury,
is you are
that is
talking about
injuries.
you are talking about accident and all.
Injuries.
If a person suffers heart attack,
well, then the question will come whether it is in the performance of his duty or exaggerated by his duty, my lord.
now if it is not related to the performance of his duty, he suffers a heart attack,
My lord.
and that results in some kind of, you see, like disability.
Then, my lord, there are two
Then-
kinds of pension, my lord. One is disability pension and one is invalid pension, my lord. If because of performance of duty,
But then
my
one
lord,
thing is here, that if soldier is not capable of performing his duty,
my lord,
he will be ousted.
he just-
This is the law. Is this the law, Mr. Jha?
My lord,
If this is the law, then you are not there.
my lord,
Even your continuation also will not be.
my lord,
relevant.
here it is on the ground of, what is the ground, my lord?
If
They say that their stand would be, if on merit, my lord, their stand would be no. ADS, alcohol dependency syndrome, does not come within the attributable to service, my lord. The pension is on the two grounds, my lord. CCS 40 invalid pension, or disability pension. My lord, that should be attributable to service and in the service, my lord.
That is what it says, yes.
My lord. So here it is, I am on the ground of the medical board itself. It is a malafide, my lord, on the part of the petitioner. On the same ground, I have been.
Let us come to your case then. Just say what is your ground then. Now, discharge on medical ground,
my lord.
what are the prerequisite for that?
Discharge on medical ground. First, my lord, there should be a medical board has to be constituted, my lord, whereby if it is assessed temporary, my lord. Firstly, the medical the
Can there be a scope of assessing permanent without assessing placing him under first temporary under temporary category?
No.
So it has to start with temporary.
Temporary.
Okay.
Temporary. There, yes, temporary. Thereafter, the permanency will come.
Now, say supposing if you are categorized at 5, category 5,
my lord,
and you are to be discharged,
my lord.
What are the prerequisites? Does it say that you will be kept in that category for 3 months or 6 months to see whether there is a development? What the law says? Do not go by the facts of your case. Do not go by what you dispute. Just tell us what the rule contemplates.
Rule contains, my lord, if it is any under the Assam Rifle categorization invalidation rules of 1988, my lord. It says that board, if it is called
You have annexed that
I
rule.
have annexed.
Just can you take us to there?
My lord, it is annexure 3, page 28, my lord. Entire rule is there.
Yes.
My lord, what I was contending that annual medical examination, my lord. What I was in the initial. Page 31.
See, you do not go by your contention. Just
no, my lord.
Take us to the law.
My lord,
the law says.
it's law only.
Yes.
Page 31, my lord.
That is the only set of rule which is applicable in your case. Yes. Yes.
My lord, annual medical examination of cadre officers.
Yes.
On any annual medical examination of the cadre of officer shall be carried by the regimental RMO / SMO.
You do not have a better copy with you. Anyway, just carry on. These are not very legible. Okay, regimental medical officer, civil officer of the respective battalion in the form set out in the appendix 2.
My lord, hospital or service with the approval of the administrative authority, treatment and the specialist opinion regarding the medical category based on the medical category recommended by the specialist, the cadre officer shall be brought before the medical board. The board has to be constituted, my lord. Thereafter.
In your case, board was constituted, isn't it? Yes.
Constituted.
Now, your case, do you want to say that these procedures have not been followed or these were followed?
My lord, it is after the withdrawal of the earlier cancellation order, my lord, earlier impugned order of discharge. They said that IMB will be carried. In the instant case, this was
IMB means
invalid medical board proceeding. Invalidation. So, in that, they have not carried a fresh medical board. They have relied upon the specialist opinion of the previous medical board.
Was there any bar in it?
My lord, there is a bar.
Why? Why is the bar?
My lord,
what is the stipulation of time for that? And then say like for consideration, see, so far as this is rule,
my lord,
refer to this is you read out just now what? This is rule what?
Rule. Assam
Rifle.
Rifle.
What?
Assam Rifle medical.
No, rule what? This is the what is the rule number? See, like 8 or 9 or 6 or what is this?
My lord, it is
It is not very clear here. It is rule 2, rule 3, rule 4, what? This is 3, then 5. then-
8, my lord.
Huh?
8.
8. Then where is rule 6 and 7? Is this rule 8, Dr. Mojika? Page 36. Oh, page 31, sorry.
One, two, three, four, five, six, 7. Is rule 8, madam.
Is rule 8. Where is 6 and 7?
My lord,
One,
it is
two,
on
seven.
page 28, my lord.
Page 28 is 1, 2, 3, 4, 5, 6, 7, madam.
Then A, B, C, D, E.
The definition clause comes, madam. The definition continues.
Then again come to page 30. Then what is this 1, 2, 3? How come this came?
My lord, that is the, my lord can come to page 29, shape, the term shape,
Yes.
T.
Yes.
Those
Is
were, it is miss psychological, my lord.
That's all right. You see, come to something that then this we find Roman, the small Roman 1, 2, 3, 4, 5.
Yes, ma'am.
And then therefore again these numbers are, these are not.
My lord, what happens, my lord? This is slightly technical here, my lord. There are 5 categories. The disabilities of 5 types, my lord: psychological, physical, eye. Those are 5 categories, my lord. And the degree of disability, my lord, is 1, 2, 3, 4, 5. Well, 4 is missing, so 4 is written in a hand at the bottom, my lord. 4 means temporary unfit for duties on account of hospitalization, sick leave. So he is 1, my lord, he is fit for all duties, but he should be 1 in.
It is temporary unfit. 4 is temporary unfit.
Temporary unfit. Because of hospitalization or sick leave.
Yes.
And 5 is permanently unfit for duties in the force. Elaboration of factors grades their under shape classification as per appendix 1.
Achha, 4 is written below, 5 is above.
But
now, if you say duties in force, what it would mean?
which one, my lord?
Number 5, permanent unfit for duties in the force.
Duties in the sum rifles.
Elaboration of factors, grades, under shape, classification are set in appendix 1. Achha. Permanently unfit for duties in the force.
Force is defined,
Now,
my lord.
the force
Force means
doesn't.
sum rifles, my lord.
If once you say the force doesn't take into consideration the office workers, office job things, the person who are there in the official clerical work,
My lord, in my humble
they are not part of
my lord, in my humble submission, because there are recruitment to particular categories, my lord.
Now,
There
see,
are recruitments
here
are-
what is the implication of the word force here?
My lord,
Which-
the
what is
definition
the
of
word-
force,
which we will interpret it?
page 29, force means Assam Rifles, my lord. Page 29, clause K, my lord, lordship kindly says.
Yes, Assam is the entire Assam Rifles.
Entire Assam.
So that will include all those clerical stuffs also. Then your submission that if a soldier cannot,
If he becomes 5, my lord, category 5, then he is unfit for any service anywhere, my lord,
any service under the force.
under the force.
Now force is entire Assam Rifles.
Entire Assam Rifles.
No, that is what is to be seen. Now again it comes back to the present medical condition then. Because otherwise, you see, like the court was for sometimes convinced by your submission. When you said that if a soldier, if he is incapable of performing the duty of a soldier, then he is rendered unfit. So if you go by this definition of 5 now, so we can say that even a soldier, depending on the situation, can be placed for official work inside the office, doing clerical work.
My lord, in my humble submission, my lord, there is no such system that is somebody is unfit for soldier's duty, my lord, he will be kept as.
But then
That
the law here speaks about force. And if according to you the force means the Assam Rifles, That means entire Assam Rifles. Even the civilian staffs of Assam Rifles is a part of force. Or not?
But the civilian staffs have been phased out, madam.
Now though there is no civilian staff.
Now these medical, let us just come to the point. This medical categorization rules,
my lord,
is for whom? This is for which kind of officials?
Page 28,
My lord,
clause 3.
to the entire force. My lord. Page 28.
Para 3, my lord.
See, it shall apply to
cadre officers and personnel of the force.
Person.
It applies to all.
That means all things. It doesn't make a distinction between a civilian and non-civilian staff.
There are no civilians now, madam.
In Assam Rifles?
Yes, madam. Phased out, madam.
They have been given a dress, man.
They have been combatized.
They have been combatized.
No. If you say the force, the term force used in this medical invitation rules, which takes into consideration which staffs. The force means it will include which staffs.
It says, my lord, all cadre officers and personnel of the.
So who are the cadre officers? Cadre officers are
cadre officers, my lord, officers cadre, my lord, and the non-officers, my lord.
All personnel of the force.
Personnel.
Now, if you say personnel, means in the Assam Rifles there is no civilian staff.
There is no civilian staff now.
There is no parent account section and all those things.
My lord, all have been combatized. In 1984, the policy was issued, my lord, by the central
government. So there
government.
is no clerk Havildar or anybody in the Assam Rifles.
Clerical trade are there, my lord, but with combatized, my lord.
Combatized means like they sit in uniform.
No, my lord. They are in the
okay. So they are
discipline.
soldiers.
They are
so everyone has to be soldier.
Everyone
so means,
soldier.
That means if you are a moment you are unfit, then the term force will apply only to those. I mean, like those people, those who are combatants.
Because now all are combatant in Assam Rifles.
There is no
civilian,
no combatant.
No
so it means either you are fit as a soldier or you are not fit as a soldier. So there is no scope of yourself being retained in any kind of office job, isn't it?
That is our case, madam.
Do not go by what courses if you find that goes to your advantage. Please tell what is correct.
My lord, in Assam Rifles, there are no civilian staff now. All were given the option to combatize or leave Assam Rifles in 1984. So most of them they opted. So opting for combatization meant that they had to go for soldier training, my lord, and they have to wear uniform now.
The question is that, whatever the thing, there will be some paperwork, some file work in office.
No, but
who performs?
All are trained in soldier duty, my lord.
So it means like your main job is basically to work as a soldier. That is what a main job.
But even a compounder in Assam Rifle,
but then
it has to start to carry gun, my lord, if necessary. So they are trained for that.
No, that is the necessity is one thing. We are not. Our purpose is basically to determine if a person is rendered unfit to be a soldier, whether he can be retained somewhere else or not. That is the main.
That's
what I'm saying. That all the staff will have to be a competent staff. In such a case, there is no scope of it.
My lord. And if somebody is discharged, my lord, if he has now again discharge can be on 2 counts: attributable to service, non-attributable to service.
Now, if there are some officials for discharging the duty of a peon and all, he also has to be a soldier.
He has to be a soldier.
So then basically it becomes tougher for you. It becomes a tough case for you then. In such a situation.
My lord,
because what we do, my lord, if somebody suffers any kind of...
You see, like the sheltered appointment is something, you see, like you can say like it's a stopgap arrangement.
My lord.
You cannot claim permanency in that, isn't it?
Yes,
my lord. In my reply to that, my lord, I have said that I have been discharging my general duty as a soldier. I have refuted it. If that be sheltered appointment, my lord, say for example, I have been, my lord, there is no policy that a person has to be, there is no sheltered appointment, my lord, in Assam. If that be so, my lord, respondent can show.
Then if you say sheltered appointment, that means what? That means what?
Nothing.
That means nothing. It has to mean something.
My lord.
See, now sheltered appointment means what? What are the jobs which a sheltered appointee performs?
my lord, in Assam Rifle, my lord. Earlier there was a PC public, so some used to run the PCO or CSD. I don't know, but I have not gone through
No. See, if
any
you
policy.
if you say the term sheltered appointment would include which kind of service? Is there any distinction?
My lord, I will that point, my lord. Shelter appointment is there's nothing called a shelter appointment in Assam Rifle, my lord.
Then from where that term has been used?
My lord, by the respondent, my lord.
Yes, Dr. Majigam, how do you explain what is sheltered appointment? Where do we get legal definition of sheltered appointment?
I'm trying to look, my lord.
No, you see, like this, we have to be very much correct in our concern.
My lord, I'll answer that question, my lord, but only
Because
one.
this all along, right from the beginning, this court was under impression, even if a person, because of his medical reason, he is not been able to perform the duty of a soldier, he may be retained in some other position until and unless he is found totally incapable. That was the concept which this court was having. Now, after hearing you and all this, like the concept changed. Now, and you said like that he's a soldier, he has to perform the duty of a soldier, and just because of the stay order, he's been like kept in a sheltered. Now, what is the sheltered appointment?
Yes. That answer I'll take this section, but only one point I wanted to just point out. Page 44 of Lord kindly says, in the of the writ petition, my lord.
Of the writ petition. No, you have to give us since you have used that thing, the sheltered appointment.
My lord. There must be some maybe some executive instruction or whatever. My lord. I'll just try to find out.
Yes. Page 44.
Page 44.
Yes.
At the top, it says, Maran, an officer can be placed in grade S3 only for a temporary period, on a temporary basis for the maximum permissible period of 48 weeks. He cannot be awarded classification S3 permanently. If on the expiry of 48 weeks in temporary S3, it is found that he cannot be upgraded, the officer will be downgraded to classification S5. And then S5, just 2 lines below, my lord, S5 is mentioned.
Yes.
Mentally unstable on account of psychological, psychiatric disorders, psychopathic personality, permanently unfit for force duties. So he has been declared that.
Now, what was the psychological disturbance he caused all these 6 years? Except for saying that he was absent from duty for some period of time, whereupon he has voluntarily returned of himself, and you have taken some punitive action against it. There is nothing in your affidavit.
Well, medical categorization has not been carried out.
That is all right. Even so far as the performance is concerned, nothing is there in your affidavit. You do not say that he was incapable of rendering any kind of service and he is lying idle, he is not doing anything.
Well, that will again come back to the same question, my lord, lordships. Whether because since there is no concept of giving a lower appointment or a simpler appointment to anybody, because a soldier unfit means he has to go home, my lord, but he will be entitled to his invalid pension, disability pension, whatever pension is entitled to. And that is quite substantial, my lord, as good as getting the full pay only. But if provided the disability is on account of
even supposing even if this discharge order is upheld, he will be getting something.
He'll be getting.
So that will I mean at least so far as survival is concerned.
It is not a case of dismissal from service; it is a discharge from service.
That we understand. So it means like he'll be getting something invalidation pension or something he'll be getting. Now that is one way to see it. But then now you say like the sheltered appointment. Now this becomes quite vital for this court to go into. We would like to know what is sheltered appointment. And for how long a person can be kept in sheltered appointment? And what kind of job he can perform in sheltered appointment. These 3 things you have to give us details. Now see, categorization or the classification as S5 is something where a person pays to recover even after 48 weeks of his temporary categorization under
My lord.
so that will be automatic.
My lord.
That is beyond recovery, isn't it?
Because once someone is declared S5 means
So
my
he was kept under S3 in 48 weeks.
he was kept. My lord.
He was
You said in our affidavit.
Even then, he did not show any sign of improvement.
He showed us some signs of my lord. Then on the
Relapse. There is a relapse.
I'll just take your lordship to page 2 of my affidavit. My lord. Para B.
Of your affidavit.
My lord. Main affidavit, my lord, July 2018.
Page?
Page 2.
The first page of your affidavit.
Page second page, page 2, my lord. Sub para A on the top, my lord.
No, you are. This is. Acha. Yes, yes. All right. Yes, page 2. Correct. Yes.
So, my lord, I'll not read the entire para. I'll just read the last sentence of para A, my lord.
Yes.
Lords, you can see the sentence starts with instructions for medical examination.
For medical examination, yes.
And classification of personnel in the CPM, but the psychiatrist gave him another chance to continue in service, get medical treatment and further management, thereby placing him in a low category S3 temporary again with effect from 27/1/17. The petitioner was advised by the psychiatrist to abstain from alcohol and take medicines regularly. Then what happened? Para B, my lord.
Yes.
The next medical review of the petitioner was due on 14/7/17 after 6 months, my lord. However, despite clear advice to abstain from alcohol, the petitioner didn't pay any heed to doctor's advice and kept on consuming liquor consistently, which deteriorated his health condition. The petitioner was found in an intoxicated state and was brought to the unit hospital in unconscious state with injury in his chin on 28/3/17. The medical officer of 2nd Assam Rifle found symptoms of alcohol dependence syndrome relapse in him once again. Therefore, the petitioner was referred to Assam Rifle Composite Hospital, Sukhobi on 30/3/17 for better management of alcohol withdrawal features, medical review and opinion by the psychiatrist. The petitioner was diagnosed as a case of alcohol dependence syndrome relapse again and was downgraded to low medical category S5 with recommendation for invalidation from service by the psychiatrist on 10/4/17. Based on the opinion of the psychiatrist dated 10/4/17, a board of officers was convened by the Assam Rifle Composite Hospital, Sukhobi for invalidation of the petitioner. The board of officers, after careful examination of the medical condition of the petitioner, found that he was permanently incapacitated for further service of any kind in the department due to alcohol dependence syndrome relapse in low medical category S5 and recommended him to be invalidated out of service. The invalidation medical board was held at 2nd Assam Rifle and his discharge release from service on medical ground was ordered on 1/1/18 by DGR number so and so dated 8/9/17 after approval by the competent authority.
So these facts are not, the factual aspects are not disputed. There is no dispute to this.
My lord, we have denied that. My lord, page
What is your version of the story?
page 34, my lord, can come. What is the specialist opinion? Dated, specialist opinion dated 2016.
See, Mr. Jha,
my lord.
If you want us to go and appreciate all those things, it will be quite difficult for this court. Because the merits is one thing you may not see. Only we are concerned about whatever is contemplated in that medical invalidation rules, whether those provisions have been followed or not. These are the main things. And if you say that, you see, like this, there is an apparent falsity in their thing, okay, then burden will be totally on you to show how it is. You have not alleged malafide against any officers, isn't it? Any particular officers, isn't it? That is not your case. Then you want us to see which page? Page
34 of the affidavit, my lord.
Your affidavit?
No, my lord. Their own affidavit, my lord.
The same affidavit?
My lord.
That is a specialist opinion.
My lord.
Based on which medical board was constituted? Yes.
This is
clinical history. Yes.
This is dated, my lord, 16. 2000.
Where is the date?
My lord,
27th February 2018. Down below.
no, my lord, on
Watch.
top, my lord.
Page 34 you said, isn't it?
Yes, my lord.
Yes, yes.
30th September 2016, on top, my lord.
Yes. Summary and opinion by second in command, isn't it?
My lord.
Rajendra so and so, yes.
30th,
Yes.
16, my lord.
Yes. Now, which part you want us to read?
That was only a recommended S3 T24, my lord. Below.
Yes. Yes, 3T24.
T24. After this, my lord, no.
So what it mandated says, supposing if you go by this,
No.
that means you are supposed to be kept under observation for 24 weeks.
No.
Isn't it?
No.
Altogether it is 48 weeks.
48 weeks.
So this is the first phase of T2 to 24 or second?
This is the only.
This is starting of S3, or before that you were categorized S3. See, this court's understanding is very less about those things. You must be doing, knowing
the
it
first,
more.
my lord. We have stated in the
This was-
first paragraph of our affidavit. 3916 was first 24 weeks, my lord. My lord, may I take a lordship to the
3916 was the first.
first, my lord.
So thereafter again another 24. That
My
is
lord.
what the rule contemplates.
My lord.
So without 48, giving him 48
My
weeks, he cannot, isn't it?
My lord, second one was on 27/1/17, my lord. Second 24 weeks was given on 27 January 2017.
Where is that? And that is stated in your affidavit.
In my affidavit it was stated. The document, it appears not been annexed.
Okay. And then what is the decision of the medical board? When did the medical board set?
Specialist
When did it-
opinion. There is no specialist.
That is not your case, that the 48 weeks was not given to you. Not this is it your case? No.
Yes, my lord. I have in the ground.
Yes. No, if that be the thing, if you can show that, then definitely this will be ground for interference. But then you have to show us. Now, you see, now if it is from 30th September 2016, if you say that you have been placed under S3, now when you are categorized to be placed in S3, whether that needs approval of the medical board or no.
Definitely.
So it becomes effective only after the approval.
Approval of the.
And then that period of 24 week is counted from which date?
After the approval. My lord.
Is it correct? Yeah, are you following Dr. Mojika, what this court is asking? Now the question put by this court is that categorization, which is recommended by the specialist, whether that requires any approval by the medical board, and that the competition of period of 24 weeks, does it start after the approval of the medical board or from the date of the opinion of the expert?
The approval, I didn't find anywhere in the rules that for medical categorization any approval is required.
Then the categorization, when you say that, come to the provision where you said, where we see this thing, this categorization. Let us see.
Para 9, my lord, page 32.
Para 9 of the?
At page 32, my lord, of the red person. Page 32.
Red petition.
Of the red person.
Yes.
It says, my lord, medical board for categorization of.
So that is the medical board.
It only says, my lord, that medical board for categorization of so and so shall be convened when a cadre officer is considered. Now approval, my lord, in the previous paragraph we'll see.
So it means medical, the headline makes it clear that categorization is by the board.
By the board.
So it means it will be effective from the date that the board takes the initiative. Now in your case, after this recommendation was made, the first recommendation, when this board approved it, can you give us a gist of dates? This will become easier. You see, because Dr. Mojika will have to take instruction on that chartered appointment. If you meanwhile, if you prepare this list of dates, the chronological list of dates. Okay, you see, like you may not go into the previous thing until and unless you find it relevant. But then after this, the new
2018
for the new filing.
2018.
This new case. If you can give us this, that when it was first categorized with specialist, then when medical board approved, from when that, you see, like competition of period of 24 weeks started, then your second categorization under S3, then again period of 24 days, and then this will help the. Have you pleaded it by giving specific date in your writ petition?
From there I will.
No, is it there? If it is there, then you do not have to do this exercise. Otherwise, it will be difficult for this court to find out.
Specific dates.
No, what we want to see that this rule has been followed on.
Whether the after the approval, because in the rule,
as per the rule 9, it is medical board for categorization of categorization. There is a medical board for categorization. It is deemed. If there is nothing in the rule to show that the categorization can be done by a specialist, isn't it? He can make a recommendation as per ruling.
And approval has to be by
the medical board, which is
by the board.
You find this code very technical.
This is a new thing for me also. Because it's,
now we are trying to determine what is there in the rule book, nothing else.
So basically, I have to reply on whether what is sheltered appointment under which
sheltered appointment, and please about this part also, the medical board, the categorization becomes effective from which date? Whether it is from the date of recommendation of the specialist, or it is from the date of the decision of the medical board. Because the rule 9 starts with medical board for categorization. Now it may happen like this, say supposing that a specialist makes a recommendation 2 weeks prior to the sitting of the medical board. Isn't it? Now the law says that before you categorize him under S5, bring down to S5, you have to give him 48 weeks. Competition of period becomes important. It cannot be 47 weeks. Isn't it? So that is what.
But there is one rule which says, my lord, if there is such kinds of relapse, we don't need to wait for 48.
So there is an emergency clause.
There is an emergency clause.
Where is that? But then have you invoked the clause? Is there? Can it be generally invoked?
No, but it appears, my lord, in this case, 48 weeks are already over.
What is your stand in the affidavit? Do you say that clause was invoked?
My lord, we replied to his pleadings in para, my lord.
But then at the same time, you justify your action also.
What I can do, my lord, I can call the officer, my lord, and I can place the records also. Because
that is okay, but
everything
it has to come from your mouth.
My lord,
because
I'll call for assisting me, my lord.
You'll have to make this court understand. It is not that the officer may come and tell the facts, but then so far as you see, like making this court understand, that will be your job. Because this whatever this court is saying now, it's going as query, not as finding or opinion of the court.
My lord.
So that is what you have to appreciate. This is not a subject matter which this court regularly dealt with. Probably previously we did 1 2 matters, but then that is all you
on different aspect.
This court remembers that one, the categorization of shape 1, shape 2, and shape 3. All those
ACR 1.
Probably I do. ACR give some case matter. Mr. Jha, you please prepare.
I will prepare the.
But in para 5 of our affidavit, we have said that he will be entitled to pension.
That's all right. But then if he's a right to be retained in service, it's not his case that you are not giving him the benefits which he is entitled to after his discharge.
He wants to continue. And how much service is left also? I'll just check. He still has.
Shall we pass some specific order requiring you to clarify on that, or you just simply adjourn?
I think it will be better, madam. 2 lines order is passed, madam.
For clarifying this thing.
Clarifying on shelter appointment and.
Okay, hard landed counsel for the parties. It's up. It appears from the case record that pursuant to the passing of the interim order by this court, the petitioner has been continuing in the service, the medical report the annual medical report, that is what
Annual medical examination, madam.
the annual medical report of the petitioner for all the years pursuant to the passing of the interim order is not available with this court. On a query made in the matter, the learned DSJ submitted that petitioner they submitted that pursuant to the passing of the interim order of this court, the petitioner is serving in a sheltered appointment. Can we say sheltered appointment or serving in a sheltered? We cannot say sheltered appointment.
Use the word shelter appointment.
They use the word sheltered appointment.
Shelter appointment they have.
As a petitioner is rendering his service in a sheltered appointment. Shall we say, is it correct? Petitioner is rendering service in sheltered appointment. Is it correct?
It should be sheltered posting.
Stop. He, however, was not in a position to clarify as to what kind of duties are performed in a sheltered appointment. Stop. The learned DSJ prays for grant of some time to clarify the above aspect before this court. Clarify about this aspect before the matter is taken up for final disposal. Just tell me the last line. The land council, just last line. Clarify this aspect, full stop. Then, just paragraph, clear aloud. This is matter after 2 weeks. 2 weeks will be enough for you. Diwali will not cause any hamper.
Only 1 day. I think there's also Saturday, Sunday.
We do not know whether we dig too much into the thing or not, but then it happens when the subject is, if you are not very familiar with the subject. Yes. Mr. Jha,
in the meantime,
please prepare a list of these things that will help us.
Definitely.
Yes. Next.
Same, my lord.
Same order.
Same order. Similar matters.
Similar matter, same order.
Same order.
Same
order.
This is something very unusual, Dr. Mujika.
At that time, 3 or 4.
You were happy with people working in sheltered appointment in your department. So if you have 4 or 5 persons with this kind of allegation, so all will be in sheltered appointment, and there will be no soldier on the battleground.
Especially they don't want, nobody wants to go to Manipur nowadays, my lord. So
these officers, those who discharge them, they are not in sheltered appointment, is it? And this goes as a joke, nothing.
Yes, no, madam.
Yes.
Item number 23.
Yes, Your Lordship.
Yes.
Lordship, this legal matter, Your Lordship, and similar matter is pending